To stay on schedule, I'll probably get started. My name is Goitein, along with Faiza Patel. I'm one of the co-directors of the Brennan Center's Liberty and National Security Program, and I have the honor of moderating the next panel on domestic intelligence and the First Amendment. In 2006, a newcomer began attending services at the Islamic Center of Irvine in Southern California. The other mosque attendants welcomed him into their midst. They willingly invited him into their homes and shared their beliefs about Islam. But then he began talking about violence and weapons. The community became alarmed. They reported his statements to the FBI, and eventually they obtained a restraining order against him. It subsequently emerged that this man was an FBI plant sent into the mosque with hidden video and recording devices to capture what was said. When the community learned what had happened, some of them stopped attending the mosque, and others reported that the feeling of goodwill that had permeated this once tight-knit religious community had been replaced by mutual distrust. Mosque infiltration is one of several intelligence gathering practices today that implicate the First Amendment rights and First Amendment values. And to understand why that's the case, we need to take a step back. Since 9/11, Americans have become increasingly concerned about the possibility of terrorism emanating from individuals and groups that use Islam to justify their actions. But most Americans understand that only the tiniest fraction of Muslims in this country pose any kind of threat. And so a narrative has emerged that goes something like this. There are two kinds of Islam. There is the true Islam, which is practiced by the vast majority of Muslims. And then there is the twisted perversion of the religion that Al-Qaeda and other terrorist groups cite to justify violence. The first kind is sometimes referred to as moderate Islam, and the second kind is usually referred to as Islamic extremism or violent Islamic extremism. If we can identify people who subscribed to the extremist version of Islam, the narrative goes, we may be able to intervene in some way to prevent terrorist attacks. This narrative has been widely embraced by the public, and its emphasis on ideology drives how we think and talk about terrorism. The process of becoming a terrorist, for example, is referred to as radicalization, a word that conjures ideas and beliefs more than action. A focus on ideology is also evident in the response of law enforcement. In describing the process of radicalization, law enforcement agencies like the NYPD and the FBI have honed in on ideological indicators, which include, according to them, things like growing a beard, wearing traditional Islamic dress, or receiving religious education overseas. Intelligence gathering practices are designed to try to locate people with these ideological indicators. So law enforcement agencies are using domain mapping, which I talked about earlier, to map out ethnic enclaves within their communities where the practice of Islam is commonplace. They are asking religious leaders in their communities to report people who exhibit extremist beliefs or behaviors. And to come full circle to the Irvine example, the Attorney General has relaxed the rules that govern FBI investigations to permit the placement of informants in mosques, even if the FBI has no suspicion of any criminal or terrorist activity. This operational response raises threshold empirical questions, which I hope we'll have some opportunity to discuss today. First, despite its widespread usage, the term Islamic extremism is rarely defined. Is it true that Islamic terrorists are motivated by a particular religious ideology that we can identify and that distinguishes them from other practitioners of the faith? Second, and closely related, are there religious indicators, ideological indicators that are particular to terrorists and that can be used to spot them before they act? Beyond these empirical questions, Current intelligence gathering practices raise a host of First Amendment questions, which are really the primary focus of today's panel. And to name just a few, assuming that there is some kind of distinct Islamic extremist ideology at work, can the government accurately distinguish this ideology from religious views that are conservative or passionately held? And does it have any constitutional business trying? Are expressions of radical or extremist belief, which could not themselves be criminally punished, nonetheless a legitimate subject of law enforcement scrutiny at the intelligence gathering phase? Is it appropriate for the government to prioritize the investigation of violent acts justified in the name of Islam over violent acts justified in the name of other ideologies? And do the rules governing intelligence collection provide law-abiding Muslims in this country with sufficient protection against religious profiling? Sitting next to me today are exactly the right people to begin exploring these questions, starting with Professor Geoffrey Stone. Professor Stone is one of the foremost experts on the First Amendment in this country. He teaches at the University of Chicago Law School, where he was also the dean for several years. He's written several books and articles on the subject of free speech during wartime, including a book entitled Perilous Times, Free Speech in Wartime, which won 8 National Book Awards. And we at the Brennan Center are particularly proud of the fact that Professor Stone clerked for Justice Brennan. So we count him as one of our own. Jeff.
Thank you. So I want to talk a bit about the First Amendment, at least initially outside the context of this particular issue. Because I think if you're going to try to think about the First Amendment in a principled manner, it's important to look at the issues involved outside of the more inflammatory setting in which it now arises. So the first question is, suppose that the police have probable cause to believe that a priest is engaging in child sexual abuse. And they have reason to believe that there's evidence of this behavior in the priest's desk in the church. And so they go and get a warrant, and they search the church and the desk, and they find evidence, or they don't, it doesn't matter. And the claim is that this violates the First Amendment, because it's an intrusion of the autonomy and independence of the church. Presumably, most of us would say that the standards required by the Fourth Amendment would satisfy anything the First Amendment might impose in this situation, and that if indeed the police do have probable cause to believe that there is evidence in the church of this behavior, that as long as they comply with whatever the Fourth Amendment commands, that gives them sufficient justification to do this. And indeed, that would seem pretty clearly to be the law. Now, suppose that we change the situation a bit, and suppose that the police don't have probable cause. They have a hunch that a particular priest is involved in child sexual abuse, and they therefore couldn't get a warrant and couldn't literally search the church or the desk, but instead they decide to start attending church services to get a better sense of this priest, and they infiltrate the church community, and again, let's assume they find that this is in fact the case, and they get evidence of this from their surveillance, and the priest is prosecuted, and the priest claims this violates the Fourth Amendment and the First Amendment. Well, as to the Fourth Amendment, under existing law, well established, although probably wrong, there is no violation of the Fourth Amendment in a situation of this sort, because one has no reasonable expectation of privacy in the assumption that the people with whom you're dealing are actually who they say they are. And if you're simply deceived by someone into revealing information about yourself, and you expose to them, as you would any other person who's in your company, aspects of yourself, then there's no Fourth Amendment search and there's no violation. So the Fourth Amendment won't help in this situation. So the question then is, does the First Amendment prohibit the police from attending the church services when their reason for doing so is to determine whether, in fact, this priest is engaged in child sexual abuse, where they don't have probable cause, where they're acting merely on a hunch or a possibility. Are the police not allowed to attend the church services because they're there as police for this purpose, when anybody else could walk in and sit down and attend the services? Are they debarred from doing this, even though everybody else is allowed to do it? Well, the answer to this under basic First Amendment law is that the First Amendment does not prohibit this. That if the government is involved in otherwise legitimate activity, which it could do, for example, if it was a private school and it was a teacher in the private school who was thought to be engaging in this type of behavior, police officials could enter and there'd be no First Amendment argument to speak of, or if it was a business, they could do the same thing. So the argument then would be, well, it's different because it's the church. But under the First Amendment, if the government is engaged in activity that has only an incidental effect on religion or speech, that basically there's no constitutional violation. So in this context, the government's interest has nothing to do with the fact that it's a church or that it's religion. It's no different than if it was the school or if it was a business. It just happens in this case, the concern is that it's a church. And the basic approach under the First Amendment is that, barring extraordinary circumstances, that does not violate the First Amendment, whether it's speech or religion. And as long as the government is not directing its attention specifically at religion or speech as religion or speech, that the First Amendment isn't violated. Now, there's an exception to this, narrow exception, which is worth noting, illustrated by the decision in NAACP v. Alabama, which was the case in which the state of Alabama in the late 1950s required all out-of-state organizations to reveal their members. And this was being applied, as a matter of course, to the NAACP. And the NAACP objected that even though this was an incidental application of a statute having nothing directly to do with speech organizations, or the NAACP in particular, that it would have a severe chilling effect on its members and on the organization if they were required to identify themselves to the state. So in a situation where the law has an incidental, or the practice has an incidental effect on speech or religion that's demonstrably severe, there's an exception to the general rule. But presumably that would not apply in the example that I gave. So the first answer then is, to the extent what's going on is investigation of criminal conduct, and the investigation is taking place in a church or in a mosque or in a synagogue or in a speech as opposed to religious activity, the First Amendment is not going to impose any appreciable constraint on the ability of the police to do that. Now, a different situation potentially arises if the government is investigating precisely because what is at issue is speech or religion. So if instead of investigating a priest who happens to be a priest engaged in arguable child sexual abuse, it's investigating the speech or the religion that takes place in a particular facility, because the religion or the speech itself is thought to be harmful, damaging, dangerous. Then the First Amendment comes more into play, because you're not talking here about an investigation that has only an incidental effect on speech or religion. Now it's the speech or religion itself that is triggering the investigation, right? So the simple example of this is that there's a cleric who is giving speeches that are seen as radical, and in his mosque, and the government wants to enter the mosque for the purpose of listening to those speeches and seeing who's in the audience, and making a list of the people in the audience to make sure that they can track them and find out if they're potentially dangerous. Now, and this is a different case because it's not a case where the investigation is totally incidental to the religious activity. It is the religious activity that is getting the government interested. The question, though, is it unconstitutional for the government to do this? Well, the first obstacle that we face under the law in this context is that the courts have been very reluctant to allow anyone to have standing to challenge this type of activity if the only harm that they can demonstrate is that they are chilled. That is, the mere fact of being chilled in and of itself, the courts have said, does not give standing. Otherwise, virtually anyone could sue for almost anything they don't like in the realm of speech, and that would just be too open-ended. So even if one concedes that what's happening is what I just described, it would be very difficult under existing law for anyone to actually sue to challenge the constitutionality of that infiltration, even if we assumed it was a violation of the First Amendment, because they wouldn't have standing to do so. So now let's assume that someone does have standing, right? Let's assume that an individual is arrested because of subsequent events, and the evidence being offered against him is that he heard that speech to show his own radicalization. The question then is, well, now that he has standing, would it be unconstitutional for the government to engage in this investigation? And there's no law on this question. There's no definitive precedent, or even close to definitive precedent, on this issue. The problem with trying to make a doctrine on this issue is that the number of problems, number of situations in which this type of problem arises are limitless. It's the police monitoring a demonstration. You know, are they there because they want to see who's at the demonstration, or because they're trying to keep the peace? And you can, again, spin out endless examples of situations where there's a mixed motive problem. And so the difficulty is, if you were going to rely on the First Amendment to solve this problem, you've got a very difficult road to travel. And with the current Supreme Court, it's a road that isn't going to go very far. So I think more work needs to be done on this question as a matter of principle, as to whether, in fact, a coherent theory can be articulated that would persuasively say that, yes, this is a workable doctrine that says that government investigation of activity that is religious or expressive can be unconstitutional, even where the government is doing it for the purposes of law enforcement. All of that suggests that much more attention fruitfully should be paid to other constraints on government than bringing First Amendment lawsuits. And here I think the question of the guidelines, the FBI guidelines and so on, the Department of Justice guidelines, become much more important. Because even though the First Amendment doesn't prohibit something, it doesn't mean that the government can't exercise restraint and can't place restrictions on its own behavior because those behaviors are problematic, whether or not they're technically a violation of the First Amendment. And this is exactly what happened with the Levy guidelines, put in place by Attorney General Edward Levy under Gerald Ford, which was after COINTELPRO and their church hearings and so on came to light. Levy put in place guidelines that said that federal agents may not investigate religious or political organizations unless there is at least specific and articulable reason to believe that illegal conduct is afoot. And that's been watered down in the years since then. But I think that's ultimately a much more fruitful way to go, particularly with this administration, and putting pressure on them to adopt those sorts of rules, at least from the federal government standpoint, would be useful. That doesn't get us to the state or local government, but at least to the federal government. Thank you.
Thank you.
Sorry not to be more encouraging.
Our next speaker, who I'm not sure if she'll be more encouraging, is we're very fortunate to have her on rather short notice. It's Nura Maznavi from Muslim Advocates, which is a leading national organization that uses litigation, community education, and policy advocacy to shape federal policies affecting the American Muslim community. She is the leader of Muslim Advocates' program to end racial and religious profiling. Before she was with Muslim Advocates, she was a civil rights litigator, and she's also served as a staff attorney to the Ninth Circuit Court of Appeals. Nura?
Thank you, Liza, and thank you to the Brennan Center for hosting this extremely important symposium today. Muslim Advocates is a national legal advocacy and education organization. Our mission is to promote and protect freedom, justice, and equality for all, regardless of faith. These are values that that are at the core of our Constitution and who we are as Americans. Through our work, including Know Your Rights presentations, seminars, and trainings, my colleagues and I have direct contact with American Muslims across this country on literally a daily basis. We hear the stories of American Muslims who are experiencing, on a deeply personal level, the reality of the legal and policy issues that we're discussing here today. My comments will focus on how these policies and practices are having an impact on the lives and constitutional rights of everyday Americans. I want to start by first stating very, very clearly that American Muslims care about the safety and security of our country and do our part to protect our nation. At the same time, they also demand the same rights and protections of other Americans. Today, almost 10 years after the tragic events of 9/11, there is an incredible amount of fear and apprehension within the American Muslim community. This fear is threefold. First, there's a fear of possible retaliation by federal agents if individuals in the community speak out against surveillance abuses. There's also a fear of backlash from the American public as we see an increase of anti-Muslim sentiment sweep this country. And finally, relevant for this panel today, there's a fear of exercising constitutionally protected rights, going to the mosque, donating to religious charities, welcoming new Muslims into the community, and speaking your mind about politics, religion, or foreign policy. So how did we as a nation get to the point where Americans are nervous about openly practicing their faith or speaking freely about political or religious affairs because they just might be monitored by federal agents who could misinterpret their actions or speech? Let me tell you. In late 2008, the Attorney General guidelines and the FBI's guidance implementing the AG guidelines were significantly revised and loosened to allow for the types of surveillance tactics that our country has not seen since the surveillance abuses of the 50s and 60s, the monitoring of Americans' religious and political activities, and the infiltration of houses of worship by federal agents or informants with no evidence of criminality. Liza just told us about one of the most high-profile incidents of the use of informants in a mosque in Orange County, California. This incident was significant not just for the details that emerged from the informant himself, but because amongst the American Muslim community, it was a public confirmation of a practice that they know is going on in communities and mosques across this country. It's a practice that we as advocates know is going on because we get those telephone calls about people approached by federal agents to spy and report on fellow community members, and community leaders who are asked by federal agents to report on the religious practices and political beliefs of their own congregants. Can you imagine if your priest or your rabbi was approached by federal agents and asked to share their thoughts about the political or religious leanings of members of their congregation? That's what's happening in the Muslim community today. Many in the community think that if they keep a low profile, watch what they say and who they associate with, they will be able to stay off the government's radar. But we know that's not the case. I want to highlight a few stories that we've received at Muslim Advocates. The first is of a young Muslim college student, an all-American kid on the honor roll and involved in campus's activities as well as in his local mosque. He's been in the US since he was a child but was out of status, something that the authorities knew about for over a decade. However, it was not until agents started investigating his local mosque that he was picked up by federal agents. He was threatened with deportation. Then they told him that maybe he and the agents could help each other out. They would clear up his immigration issues if he agreed to report on the political and religious activities of members of his mosque. We've heard the same story from other American citizens, including a community leader who was active in his local mosque and regularly in contact with the FBI as part of their community outreach. One day, the tenor of these meetings changed, and agents started asking him about the political and religious beliefs of other congregants, their views on the war in Iraq, their opinion about the Palestine-Israeli conflict. When he refused, saying that he thought sharing such information was inappropriate, they threatened him by suggesting that they would tamper with his mother-in-law's adjustment status, commenting, "It would be a shame if her paperwork were somehow misplaced." These are just a few stories. We also regularly hear from American Muslims who are approached by authorities in their homes and offices because of political or religious postings on Facebook or involvement in their local mosque. The net impact of these tactics is a chill on the free speech, practice, and association of American Muslims. It is not only eroding the trust, it's not only eroding the rights of these Americans, but it is eroding the trust between many members of the community and law enforcement and between community members and their organizations. As if this invasive questioning wasn't troubling enough, this type of questioning is practiced by more than just the FBI. It is also regularly practiced at airports and border crossings by Customs and Border Protection agents targeting Americans coming home after overseas travel. Muslims, and those perceived to be both citizens and non-citizens, are being detained, searched, and interrogated about First Amendment protected activities at the border. Sometimes these searches and interrogations are accompanied by intimidation and harassment, with individuals pulled out of their cars and handcuffed in front of their families, or individuals searched and questioned by federal agents with their guns drawn. Border agents interrogate travelers with questions like, how many times a day do you pray? What mosque do you attend? What religious charities do you donate to? How many gods do you believe in? And what are your views on American foreign policy? Can you imagine returning home from an overseas trip, getting off the plane after a 10-hour flight, only to be hauled into a small room and questioned for 4 to 5 hours by armed federal agents about whether or not you believe in God or if you pray? That's the reality for many American Muslims today. We do not yet know the precise extent to which DHS allows for this type of First Amendment questioning as a policy matter, although we do know that federal agents have wide latitude and discretion at the border. In 2009, Customs and Border Protection issued a directive that allows for the electronic search of electronic devices, including computers, cell phones, and digital cameras, without reasonable suspicion. We know that information collected during these interrogations and searches are shared with other federal agencies. I won't go into too much detail about these specific cases because Muslim advocates published a report in 2009 which profiles dozens of people who have been detained and interrogated at the border. We also sent a formal complaint about this issue along with the ACLU to the Inspector General of the DHS late last year. But I'll end my remarks with one story that best encapsulates the extent of this questioning and the impact that it's having on the lives of ordinary law-abiding American Muslims. It's a story of an American citizen who traveled to India on business and stopped in Pakistan to visit his ailing mother. Upon returning home to the U.S., he was detained by agents at the airport and searched and interrogated for over 3 hours. He was asked about donations he had made to his place of worship in the U.S. The agent went so far as to tell him that he shouldn't have made the donations. Agents also asked him about why he chose to enroll his children in an Islamic school and questioned him about the identities of individuals whose pictures he had in his wallet. His computer was seized and copied, and his cell phone was confiscated and mailed back to him 1 month later, broken and unusable. The search and interrogation did not stop there. A few weeks after his trip, FBI agents visited him in his home. They interrogated him at length about information he had supplied to agents at the border. I tell this story not because it's the most outrageous one that we've heard, but because of a follow-up conversation I had with this man that exemplifies the chill that this type of questioning is having on law-abiding Americans. He said to me, "I took a business trip and visited my sick mother, and because of that, I am treated like a criminal. I was questioned about my faith and family when I was coming home to my country, and then again in my own home. I have a trip scheduled to go to Mecca for the pilgrimage. I'm nervous about my trip back, and my family doesn't want me to go because they are worried about what will happen to me at the airport when I come home. We don't want any more trouble. Should I cancel my pilgrimage?" Thank you for allowing me to present the community perspective on this issue, and I look forward to your questions.
Thank you so much, Nura. Our next speaker is Kate Martin. For almost 20 years, Kate has been the...
More than.
Really? The director for... anyway, I thought it was almost... Apparently it's more than 20 years. Kate has been the director of the Center for National Security Studies, a think tank and advocacy organization that is probably well known to many of you. She regularly testifies before Congress and is a prominent voice in the media on issues of civil liberties, and national security. She somehow also finds the time to serve on a number of task forces and committees, including the ABA's Task Force on the Treatment of Enemy Combatants, and she has taught classes at the Georgetown Law School and the George Washington University Law School. Kate?
Thank you, Liza, and thank you to the Brennan Center for this incredibly interesting and helpful conversation. And Liza had asked me to make the point and outline some instances where this kind of investigation and surveillance has affected communities other than the Muslim American community, which I will do, but I have to say, listening, I do think that the problem is much more severe today about surveillance of the Muslim American communities than other communities.
Agreed.
But if you take a look in September of 2010, the Justice Department Inspector General issued a report on FBI investigations of the Quakers, anti-war groups, and some others, which is the illustration that they're not simply focused on Muslim Americans. It's interesting to me because the first time I remember working on this problem, which is actually, I think, in some ways, doctrinally a very difficult problem, had to do with the context in which doctors who were performing abortions were being threatened and killed. And there were groups who preached and advocated that abortion was murder, that it was morally justified and maybe even morally compelled to stop the murder of innocents, and perhaps violence was morally justified in order to stop the murder of innocents. And so the question became, if you're trying to find the killers of the doctors, can you investigate these groups? And how can you investigate the groups? And is it enough that the groups have advocated the position that killing the doctors is morally defensible or maybe morally compelled? And is that enough for the FBI to investigate those groups? And so I'm not sure we ever answered that. Well, at the time, the civil liberties answer was no, that's not enough to investigate a group or an individual. And then the question was, well, what additional fact do you need for the FBI to legitimately open an investigation? And which I'm hoping Chuck will answer. But at the time, what we kind of bantered around was, well, if the individual or the group, the anti-abortion protester, buys a gun, but what we didn't realize was that buying a gun was exercising a constitutionally protected right. So that answer no longer works. So one of the hard problems in this field, I think, is that we used to think that we could easily articulate a distinction between criminal conduct and protected speech, and that that on the one hand, the government can criminalize constitutionally the planning of violent acts, and on the other hand, under the Brandenburg decision, that defense or advocacy of the violence is protected by the First Amendment, except in the narrow circumstances where what your intent and likelihood is that violence will follow immediately. I think that line, which is a line about what can be criminalized, not what can be investigated, has itself become blurred since 9/11, and most prominently with the expansion of the material support laws. But then you have the question of, if we have a rule that says the law enforcement has to focus on criminal conduct, And that has to be its objective, a rule which used to be much more the case than is any longer. But how far back from criminal conduct do we want to allow law enforcement to go in investigating and trying to prevent the criminal conduct before it happens? And, that's the hard question I think that's before us today. We have, not just today, but I think throughout our history, the situation of violence being carried out for political, ideological, religious reasons, and obviously a strong national interest in stopping such violence before it happens, and yet a recognition that government surveillance and investigation of religious or political views is likely to chill the exercise of those views. One of the things that's changed, I think, since 9/11 and made it harder is that it's no longer just a question of chilling. Investigation, Fritz said that what the FBI had done during COINTELPRO days, of course, was try to disrupt or harass and destroy people, which they did in totally illegal ways. But they no longer do that because the criminal law has expanded so much and immigration law has expanded so much that the government has much larger number of legal tools with which to go after people they find or identify in the investigative process. And just to tell one horrifying story, many of you in this room were involved with me, as I was, in challenging the roundup of people in the United States in the first 3 months after 9/11, 1,100 people who were suspected of being Arab or Muslim were jailed because they were suspected of being Arab or Muslim. And most of them ended up, or the majority ended up not being citizens, and they were charged with being out of status, and some of them voluntarily left, and a lot of them were prosecuted. And so I raised this actually with a high-ranking Justice Department official, that this was religious profiling and religious discrimination, because if you have a country with 11 million people out of status and you decide to put all of your enforcement efforts targeted against Muslim and or Arab communities, that's discrimination. And he was very adamant that it was not discrimination, it was a reasonable prioritization of resources when you can't deport everyone. And I think that is the fundamental argument on the other side, that people are out of status and we can't deport everybody, and so who are we going to choose to deport first? And that argument and that problem needs to be understood as part of the surveillance problem, because they're now much more linked than they perhaps used to be. And am I out of time?
We've got a couple minutes if you want to.
So then I just want to talk briefly about what Jeff mentioned, which is I agree that the chances of doing anything about this in the courts are almost nil. That leaves us with Congress and the administration changing the Attorney General guidelines. The Attorney General guidelines, when they were first adopted, were adopted specifically to protect First Amendment activities from surveillance. And so they didn't simply set up rules that said, here are the standards for when you can use specific kinds of techniques, when you can open an investigation, when you can ask someone questions and identify yourself as an FBI agent, when you can use the much more intrusive technique of pretending not to be an FBI agent and ask somebody, or the even further technique of sending someone who's not an FBI agent but recruiting them to be a covert informant and sending them into a place of worship. There was a whole series of rules that were meant to limit when those techniques could be used and basically tie them to the level of evidence or suspicion that existed that a crime was being planned or had taken place. Those rules have been watered down for many years, but extremely watered down during the last administration. The other part of the rules, which I think is key, is that it's not simply rules that say, here's when you may conduct certain kinds of investigations, but the other part of the rules is to say, if you're going to look at speech or religion, etc., Jeff's example of you're going to send someone into a mosque for the purpose of listening to the sermon, that you need to have much higher standards than usual because of the First Amendment problems and the First Amendment chill. That Attorney General Ashcroft rejected that notion totally. He said, that's absurd. Why, if the public can go into a mosque, should we have any requirement whatsoever about when the FBI can go into a mosque? And that, I think, was one of the major erosions of protections that happened. All of those erosions happened in a context which also has to be taken into account to understand the full extent of what has happened. And that is, there's been a change in the understanding of the threat and the mission of the FBI and local law enforcement. And it's much more focused on the idea that religiously motivated violence is somehow the major threat to the United States. There's been a vast increase in technological capabilities for surveillance, so it's much cheaper and much easier to surveil many more people than it used to be. And at the same time, there's been a vast increase in the amount of government resources put into law enforcement. I think I'm less sanguine than Matt Waxman this morning that the future architecture of law enforcement and intelligence will be driven by the nature of the threat. I think that what we've seen is that the architecture is being built based on a lot of different factors. Unfortunately, it's become a question for partisan debate, which doesn't lead to reasonable answers, usually, I don't think. Finally, I think it's not a problem of just the FBI or just today. I think it's a perennial problem because it's, as someone said this morning, Sheriff Baca, I think, said, it's very hard to find the actual terrorist who has no interest in being found, and that it is much easier to focus on people who may share some of, or appear to share some of the same ideas that are viewed as motivating the terrorist. And so you have this kind of bureaucratic incentive, right, to do something. We have the problem of increased criminalization and whether or not we've looked at that as a society and whether or not we really want to go down that path and what that means. And finally, I'll just end, because I'd be interested in people's reaction to this problem. So I tend to think of this as the Raskolnikov problem, even though I haven't, since it's been decades since I've read Crime and Punishment, I'm not sure that this is, my memory of what happened in Crime and Punishment is correct. But so the FBI's mission is to prevent the next terrorist attack before it happens, a mission I wholeheartedly endorse as necessary and wise and good. But what I take from the story of Crime and Punishment is that that human beings decide at different points whether or not they are in fact going to go forward and murder the old lady. And the criminal law in this country used to be very attuned to that problem and say, well, thoughts of violence are not going to be criminalized in this country, although, of course, they are criminalized in totalitarian countries. And we are going to require some actual step along the path to violence before we outlaw it. That basic notion, I think, has been challenged and is insufficiently talked about and respected in the current climate in which we try to prevent the next act of terrorism.
Thank you, and I'm going to have a question for you about that a little bit later.
That's
Yeah,
only-
exactly about that. Our final panelist today is Chuck Rosenberg. Mr. Rosenberg is currently a partner at Hogan Lovells in Washington, D.C., and he came to the firm from a long and extremely distinguished career in law enforcement. Most recently, he was the U.S. Attorney for the Eastern District of Virginia, which, along with the Southern District of New York, which many of you are maybe more familiar with, is one of the top districts in the country for prosecution and for terrorism and national security prosecutions. Before that, he held several senior posts at the Department of Justice, including Chief of Staff to Deputy Attorney General Jim Comey, Counselor to Attorney General John Ashcroft, and Counsel to FBI Director Bob Mueller. And in all of these positions, he focused on counterterrorism, national security, counterintelligence, and some criminal matters. Welcome.
Thank you very much, Liza, and thank you for having me as part of this panel. I really do appreciate it. One editorial comment. As you described, Liza, I've had an extensive background in federal law enforcement, and I think there are virtues to that, but there are also dangers to that, because I've spent most of the last 2 decades talking to people who agree with me on just about everything. And I find it pretty difficult sometimes to come into a different setting and listen rather than just talk. I found myself trying very hard. In fact, I even wrote down in my notes, listen, don't just talk. And I just ask you to bear with me, because I struggle with that sometimes. I believe very strongly the things that we've done in law enforcement are good and proper and necessary, but we're not perfect. And I understand that, but maybe I'm just being defensive here. I remember the loneliest day in my entire life was when I went to the American Library Association to talk about the Patriot Act. I mentioned to them how apprehensive I was, and they said, "Come on, don't be silly. After all, we're just librarians, for God's sake. You will get out of here alive." And I did, and I hope to do the same here. A couple of words about the Domestic Investigations Operations Guide, which was issued in December of 2008. Previously, there had been several iterations of it at the FBI, one for criminal investigations, one for national security investigations, yet another for foreign intelligence investigations, and they were all worded just a little bit differently, and you put them all together and they were extraordinarily confusing. And so while some people may look at the newest issue as nefarious, really it was an attempt to consolidate a bunch of things that were floating around and that were causing some confusion at the Bureau. It was sort of vetted on the Hill through oversight hearings and with congressional staff and members. It was coordinated with numerous outside advocacy groups, and there was a rigorous internal procedure to make it as good as we could make it. Again, not perfect, but pretty good. As you all know, it's also largely unclassified, so you can read it and criticize it if you want, which I think is a virtue of it. I think the main point, though, on all of this, where you stand sort of depends on where you sit. As I mentioned, I've been with the Department of Justice and the FBI for almost 20 years. And I find them to be a remarkably good and careful organization. And I think Mike, who has been such an eloquent advocate and critic of the FBI, but both, I think, would agree that they are a remarkably good and careful organization, but again, not perfect. I think if you essentially trust the FBI, as I do, then the guidelines seem rather balanced and sensible and principled. And if you don't essentially trust the FBI, then they don't. And I don't know how in a forum like this we kind of get over that hurdle. I've participated in scores of panels and given dozens of speeches. I know I've never once convinced anybody to come over to my side. I'm pretty sure I've convinced some allies to go to the other one. If in fact there are any allies out here today, bear with me. A couple of points. I'll be relatively brief, Liza, and we can get to the interaction and the questions. You started with the Irvine example, and I think we all have heard of it or others like it. I think there's a danger in using anecdotes to assess and drive policy. I mean, I am not going to use anecdotes, or at least I'm going to try very hard not to use anecdotes. I mean, we always can pull anecdotes that say that if we don't do something, then something bad will happen, or look at what these people did. It turned out really bad. And Nura, and you did the same thing, of course. And I got to tell you, not to dismiss those anecdotes. I find them heart-wrenching in some cases and astonishing in others. And so it's not to dispute a word of it, but just to emphasize that there are plenty of anecdotes, and we ought to be careful not to rely on them solely to assess and drive policy. The fact that something bad happened to your great uncle's next door neighbor's boyfriend's aunt doesn't mean that the guidelines, for instance, are flawed. And I think we also have a tendency in this country to take very, very complicated issues and reduce them to bumper stickers and slogans, which is not a good tendency. Maybe it's a function of how little time we have in our public discourse to try and distill complicated ideas. But it's also a function, as I alluded to earlier, of how hardened we sometimes are when we come into these debates. My second point, I think it's a very bad idea for law enforcement ever to say, we will never monitor X, or we will never go into location Y. I'll use a rather benign example, but my wife and I have an 18-year-old and a 15-year-old, and we have never, and they're great kids, they really are, thanks mostly to my wife. But we have never told them, we will never look in your bedroom, or we will never monitor your internet usage. I think telling someone that you will never go into a grocery store invites bad activity in that grocery store. So, yeah, we do have to be careful when we do go in, and we have to have thoughtful reasons for doing it. But putting anything off limits, I think, is an invitation to potentially bad conduct. During the Patriot Act debate, as you recall, there was a great amount of debate about the library provision, a provision in the Patriot Act that authorized the issuance of subpoenas, administrative subpoenas to libraries to gather records of anything from circulation records to internet usage records. And the last I heard, and Kate, you might know this better than me, Mike, you would certainly know it. I don't know that that provision has ever been used to date. Is that right? It's not fair to. Come on, Mike, is that right or not?
The Section 250?
Yeah.
Oh, yeah.
It has? Okay. Okay. It's been used. I did not know that it had been used. I remember at one point that it had not been used for quite a while. But Mike has corrected me on that. So, Mike, if you could just leave now, that would be, would be much appreciated. But even before the Patriot Act was sort of born, we still occasionally went into libraries as part of an investigation. We had a spy case. I know I said I wasn't going to use anecdotes, but it's for a good purpose. So, but we had a spy case where we followed a bad guy into a library and took a look at what he had been browsing by just hitting the browser back button, and it was the contact information for a couple of consulates and embassies to which he was hoping to pass some top secret information. So. I think, again, as a matter of policy, we don't want to say we're never going to do something. We're never going to monitor a particular, area or location. Finally, third point, for those who don't trust the FBI or the way it implements its own guidelines, I think you should at least be heartened by the fact that there are a couple of things out there to hold their feet to the fire. I'm in addition to being a law enforcement guy, I'm also a citizen. And I sort of appreciate this as well, the press, and many of you are here today. Congress, I think you had a speaker earlier today from the Congress, but rigorous oversight of the FBI and the way it uses its enforcement authority. Advocacy groups, like the one that Nura and that Kate represent, the courts, including the Foreign Intelligence Surveillance Court, the PIFIAB, the President's Foreign Intelligence Advisory Board, and its investigative oversight, or its intelligence oversight board, the Inspector General at the Department of Justice, and the Whistleblower Protection Act, and the internal controls, which you may or may not believe are in place. The fact is that it's not a perfect regime. In fact, it's far from perfect. And as an insider, I could probably criticize it as well, if not better than many of you here, because I've seen some of the flaws. But on a day-to-day basis, I see the men and women of the FBI trying pretty damn hard to get it right, and I'm heartened by it. So I think I bring a different perspective to it. I now refuse to answer any questions, particularly from Mike. But Liza, thanks.
Just for that, I think I'll ask you the first question. But thank you, Chuck, and I certainly appreciate coming into this situation and feeling like you're bringing a different perspective, and that's we so appreciate that, and it's so valuable to have the perspective of law enforcement represented at this table and to help us have a dialogue about this issue, because that's what we need to do. So we really appreciate it.
It's my pleasure.
And I'm gonna exercise. Everyone's all lining up, but guess what? It's not time for your questions yet, because I'm exercising my prerogative as moderator to ask just a few questions first. And my first question is for Chuck, and I do take your point about relying on anecdotes, but I think you don't need to do that to understand that when you make it easier for the FBI to go into religious spaces, that having the FBI in religious spaces when people know that's happening can really make people less comfortable about going to their places of worship. So if you're going to do that and make it easier, you want a pretty darn good reason. And so my question for you is, as you know, before 2002, if FBI agents wanted to go into a religious space, they had to have reason to suspect some kind of criminal activity, and they had to get approval from FBI headquarters. What was wrong with that? How did that fail? What were the were there instances in which the FBI wanted to go into a religious space and couldn't, and then a crime happened that could have been avoided? What was the evidence that that state of affairs that had existed for quite a long time was insufficient?
Okay. And just as a preface to that, by the way, I don't dispute at all, because I've talked to many friends who, the apprehension is real. I'm not here to tell you it's not. It's absolutely real. What I try and do sometimes is convince people that they should not be quite as apprehensive as they are. One of the problems, I think, prior to 2002, for instance, was that the guidelines were muddled. There were, as I said, different standards for different regimes, whether it was criminal or foreign intelligence or national security. And it was pretty hard for an agent sitting in her office somewhere in Topeka to know what applied under what circumstance. And so, could you go in under specific and articulable facts if you had them? Sure. But what about the agent who has just a hunch? A good faith hunch. Let's assume for purposes here that the agent isn't motivated by, a bad reason. What do you tell her when she has a legitimate hunch? What is she supposed to do? Do you want your FBI to be proactive and thoughtful and prevent the next attack? Or do you want them to gather evidence after the bomb goes off and then prosecute it in court? And what Director Mueller said is that, between those two models, he picks the former. And so I think what the new guidelines do is they embolden agents, hopefully acting in good faith, who have that hunch. And that's where the problem was. It was the gap between the hunch and the specific and articulable facts that made it hard for the FBI to operate.
I'm going to give other panelists, if they'd like, an opportunity to also.
Well, yeah, I'd like to say, yes, what you just said is all true, but on that same theory, you eliminate all protections on limitations on the government when it comes to these matters. So if a hunch is okay to go into the mosque, why isn't a hunch okay to search the desk of somebody? And there's a reason for having these limitations.
Of course.
And they are restraints, and they're meant to be there to restrain the temptation to err in the wrong direction.
The guide actually sets out a three-tiered system. So a hunch may be sufficient to open, look, I hate these words. I agree with what Mr. Schwartz said earlier. They're amazingly vague. But a hunch may be sufficient to open up an assessment, but not a full field investigation. And so you still have gradations in the guidelines. Again, you're asking human beings to, in good faith, apply them to a specific set of facts, and that's not so easy to do. But I don't think we're without limitations. They just may not be as strong as you would prefer.
Specific and articulable facts, like probable cause, like anything else, has a certain degree of ambiguity about it. But there was a process in place, which is the agent couldn't do it on her own. She had to go up the channel, change of command, if they wanted to do an investigation of a religious activity. And somebody would then decide whether there was, in fact, specific and articulable facts. None of that was the reason for the change. The reason for the change was they didn't want to follow the rules.
I disagree.
Well, can I just follow up and ask, what would be the objection, now that you have a coordinated, simplified set of guidelines, to providing that in order to go into a place of worship, and especially to go undercover into a place of worship, this standard has to be met, and it has to be determined by someone in headquarters, and and the standard has to be more than a hunch, and I would argue that the standard should be more than specific and articulable facts, but whatever the standard is, it's a standard. What would be the objection to that? And isn't the failure to have that mean that you fail to recognize the special protections that the First Amendment accords certain kinds of expressive activities in our country, including going to places of worship?
Which part, Kate?
Well, I guess, rather than talking about it, what about having a heightened standard for going into a place of worship under the new guidelines?
My understanding, and I'm not an expert in the guidelines, but I'm pretty good with them, is that you can't go in to a place of worship using certain techniques, a Title III, a wiretap, or an informant, unless you've sort of moved past, the assessment phase and have a predicate for either a preliminary or full field investigation.
Actually, I'm not totally sure that that's.
Emily knows. But an assessment is sufficient to send in an undercover informant. And that, I think, is... What?
Well, that was one comment that I wanted to make. The guidelines are unclassified, but the chapter that deals with this particular issue, the use of informants in religious or political communities, is actually redacted. So we don't know the details. So that was... that's...
Well, we frankly, I think we have some reason to think that they probably do impose the FBI guidelines some additional restrictions. So I think we can't jump to conclusions about things we haven't seen. I think that's, in fairness, that needs to be pointed out. But I know we could talk about this question forever, but I sort of want to, I'm going to ask one more question and then let everybody else talk. But I want to ask a question. That question was for Chuck, and this question is for everybody who was just questioning Chuck, which is, Chuck, you're off the hook.
Thanks.
I want to read you all a passage from Judge Posner's decision in a case called Alliance to End Repression versus Chicago. The city in that case was operating under a consent decree that prohibited law enforcement from investigating First Amendment protected conduct unless it had a reasonable suspicion of criminal activity beyond mere advocacy of violence. The city asked the court to remove that prohibition because it was hindering, the city said, its ability to investigate terrorists. And Judge Posner agreed and lifted the restriction. And he said the following: new groups of political extremists, believers in and advocates of violence form daily around the world. If one forms in or migrates to Chicago, the decree renders the police helpless to do anything to protect the public against the day when the group decides to commit a terrorist act. until the group goes beyond the advocacy of violence and begins preparatory actions that might create reasonable suspicion of imminent criminal activity, the hands of the police are tied. And if the police have been forbidden to investigate until then, if the investigation cannot begin until the group is well on its way toward the commission of terrorist acts, the investigation may come too late to prevent the acts or to identify the perpetrators. What's wrong with that reasoning?
I was actually one of the lawyers in the case.
Well, there you go.
Right. So Posner's reasoning was basically that here you've got great evidence staring you in the face of potential danger. Here you've got, at least hypothetically, individuals or organizations who are advocating violence. Not enough to satisfy Brandenburg, but they're advocating violence. That's a very good reason to believe that you should keep an eye on them. And you might want to do certain things to learn more about what their activities are. And the consent decree that he set aside prohibited the city of Chicago and the FBI from investigating any organization based upon their protected First Amendment activity. And protected First Amendment activity meant advocacy of law violation as long as Brandenburg wasn't satisfied. So the problem is that Dick's right. It makes it much more difficult to investigate when you can't investigate on the basis of this obvious evidence. And it does hamstring the police, but at the same time, there are other ways of investigating. And you don't have to focus specifically on this type of proof. And having said that, I actually think Dick's right. The key part of his opinion, this is a little bit off the point, but that it was a consent decree. And Posner's argument was that the government could not have agreed to these terms. They could not mean what the decree said, because why would they ever give up this right? It would make no sense whatsoever. And what Dick didn't realize is the reason the government gave up this to get the case settled is because we were on the eve of trial, and they didn't want their confidential informants called. And so that's why they entered into the consent decree. But actually, I mean, I think that's correct. I mean, I don't think you can blind yourself to clearly relevant evidence of wrongdoing. It's a little bit like Kate's reference to the guns, right? So there's a constitutional right to purchase a gun. Does that mean that police can never look at the fact as to whether certain individuals have purchased a gun in order to conduct an investigation as to whether they might be dangerous? And we would probably say that's crazy. And that's exactly the point he's making there. So I don't disagree with the proposition that he states there.
But doesn't that mean that you should be able to, the FBI should be able to go into religious spaces with something less than evidence of incipient criminal activity?
No, because beginning an investigation doesn't mean you can then pursue particular steps. And the argument would be that once you start going into religious organizations, you get into the chilling effect problems and everything else. If they want to monitor the organization that engages in advocacy of law violation, and remember that's different than religious expression generally. That itself is low value speech or whatever. So you could monitor an organization in lots of ways without intruding upon the religious or speech activities of the individuals who are connected to the organization. So that would be the difference. The fact that you can begin an investigation doesn't mean you can wiretap them, doesn't mean you have probable cause, and it doesn't mean you have specific and articulable facts to believe they're in fact engaged in any unlawful activity. It just means you can begin watching them.
I think I should open it up now to all of you.
Shahid Buttar from the Bill of Rights Defense Committee. I guess I have a question now for Professor Stone as well as Chuck. And Chuck, I really do appreciate you being here, particularly because the FBI doesn't send people out to defend its policies in public anymore, and so the fact that you are here as an interlocutor is important. So Professor Stone, I guess these are fact corrections for each of you. So if the FBI starts an investigation, it does mean all bets are off, and they can, in fact, do everything that the guidelines authorize. So unless there's an intermediate rule that the judge or somebody fashioned, right? I mean, the Posner ruling does, in fact, open the door to essentially all manners of abuse. When
I say that, I'm not accepting the FBI program.
Fair enough.
I'm just saying, as a matter of common sense, to blind yourself to that evidence would be crazy.
Point taken.
What happens next is different.
And then my question for Chuck regards one of the themes in your remarks that I particularly appreciated was the need for the FBI to cultivate and restore and ensure trust in its operations in the communities that are impacted by its operations. And 4 pieces in particular that you said that I would just invite a reconsideration of. The first is you noted that the DIOG, the Domestic Investigative Operational Guide, was vetted on the Hill. You described it as being coordinated with advocacy groups. You said it was public. And then you said later that the press and Congress could ensure oversight.
I think he was talking about the Attorney General guidelines,
Okay, well, that's fine.
which are public. Okay.
All that, though, so the parts of the guideline is fully public, but the implementing regs, portions of it, as Nura mentioned, are fully redacted, which is to say that neither the press nor Congress can serve as checks because not only are the applications of the policies secret, but the policies themselves are secret. And in the vetting with Congress wrote, many members of Congress wrote letters saying that their briefings were procedurally inadequate, and still, Valerie runs around talking about how there was this moment in time when there was people show up in a room and wave a document at a bunch of congressional aides and then pretend that that's vetting them. And the same thing with the advocacy groups. I'm curious to hear your thoughts on the process.
Fair point. I probably wasn't clear enough, and I apologize for that. When I was referring to oversight by the press and Congress, it was more broadly. I mean, I can't tell you the number of times I woke up, picked up the New York Times and said, oh my God, how did they find that out? I mean, it was almost a daily occurrence, and if it wasn't the Times, it was the Post. So your point is well taken. Parts are not public. Portions are heavily redacted. But I was talking about oversight more generally, and I don't think I was clear, so thank you.
Asim Rahman with the Muslim Bar Association of New York. Liza opened up with a couple of questions. One of them had to do with this idea that what if the government starts looking favorably towards maybe one type of Muslim group or ideology and unfavorably towards another, and that really opens up this question of the government engaging in parsing out, favorable religion versus not favorable. So my question for Professor Stone and others who might have opinions on it is, from a legal perspective, does that raise Establishment Clause issues and serious, like perhaps litigation-worthy Establishment Clause issues, or more, academic questions that really can't be answered at this time?
I don't think it would raise Establishment Clause issues. I think it would raise sort of viewpoint discrimination issues under the speech religion clauses from that perspective. So, you could argue that if the government is focusing on one particular religious belief and not another, just as if it's engaged in focusing on Democrats and not Republicans, that raises a serious problem of even-handedness. So the government would have to justify that by demonstrating that there was a good reason for that specific focus.
What if it goes, I'm sorry, can I piggyback on your
Yeah.
question? What if it goes further, such as the recommendations in the Fort Hood report that the Senate Homeland Security Committee did, where they recommended actually amending anti-discrimination laws to differentiate they call it violent Islamic extremism from the legitimate practice of Islam, I believe they said. Would that be an establishment? I read
Yeah,
that
that
in
would
an
be an
establishment. Okay.
establishment.
All right,
Yeah.
we're clear.
Thank you.
That would be unconstitutional.
Oh, go ahead.
Linda Sarsour from the National Network for Arab American Communities. This is kind of more of a question, but also thoughts from other people from the panel. And you talked about anecdotes and it's dangerous and don't use anecdotes because that's just kind of a couple of stories. I mean, we just saw that happen in the King hearings. We saw, mostly 3 people that had that one story, that kind of supported the reason why King wanted to have that hearing. So if our government is telling us not to use anecdotal information, then our government shouldn't be doing that. And it's really sad to say that they're anecdotal because this is things that are not happening to your family, they're happening to our families in our community. And I wanted to give an example when the Siraj Mateen story, the Herald Square bomber or potential or whatever he was, I obviously think that's an entrapment case, but that's a different story. What happened was the NYPD publicly, this was in the media, publicly said that this mosque, which is my mosque, Islamic Society of Bay Ridge, is a mosque that we've been infiltrated for many years before, which went public. What happens to our communities is that our neighbors that we've been trying to build relations with, other religious institutions, other community-based agencies, and other leaders in our community, see that news and hear that public information, and hinders our relationship. So sometimes what you think is just a couple of people, and this is just happening to a couple of people, it's not a couple of people, it's hindering whole entire communities and bridges that we've been building for a very long time. So I would also caution people from saying this is anecdotal and it's just happened to my grandmother's uncle's boyfriend. It's really not. It's happening to many on a massive base locally in our community here that I live in Southwest Brooklyn, but also in the entire country. So I was quite offended by that comment.
Well, I just want to interject one thing, which is it is in any situation with anecdotes, it can be very difficult to understand whether those anecdotes, for example, I would agree with you in the King hearings, how representative is that of what does that tell us? I'm not sure how much information it told us. Sometimes anecdotes are representative of a larger phenomenon, and that you need to be looking critically at what you're listening to. I think groups like Muslim Advocates have done a fantastic job of pulling together badly needed evidence so we can actually get a good big picture view of what's happening. And it does seem to me that maybe not the specifics of the Irvine example necessarily, but certainly the effect, the chilling effect, appears to be quite widespread. Now, that's a very different question from individual cases, individual things that were done, but I think the relationship between anecdotes and sort of the broader reality that's happening is an important relationship to look at. Yes?
It's Rahawala from Human Rights First. I was interested in a comment that Kate made in her comments about kind of what's that additional fact, assuming, and maybe we don't want to assume this, but assuming that merely focusing on religious beliefs or thoughts or speech that could be said to be supporting some form of violence is not good enough to open, or is not enough to open some initial form of investigation. And I don't know the guidelines well enough to know the different stages of the investigations, so maybe it makes a difference what stage you're at. But I guess what in your view, and I guess that I would direct this to Kate or Nura or anyone else who wants to comment, what additional facts would be enough, I guess, to open that initial stage of an investigation?
Well, the simple hypothetical answer is that in the Operation Rescue, the abortion example is that if a person is a member of a group that advocates the morality of killing doctors, and that person is seen in the company of an individual who's been arrested, has been seen in the company of an individual who's been arrested for attempting to kill a doctor, that's enough, in the company of. But, Mike probably, but you can then construct lots of different, it's interesting when Judge Posner says, well, that's not enough, because in the one place where this prohibition is written into law is in the Foreign Intelligence Surveillance Act. It says you can't consider an U.S. person a agent of foreign power. You can't consider a U.S. person a target for a secret foreign intelligence wiretap, quote, based solely on First Amendment protected activity, which means you can't have a wiretap, which is obviously Fourth Amendment technique, but you can do other things.
Yes, maybe just a quick follow-up or comment. Maybe the more interesting question is, even if we can point to some specific additional facts, is there a way to generalize a principle from those facts that can be workable or something like that?
Well, the principle was actually the other place I meant to mention. It was in the law in 1992 when it was first made a crime to provide material support to a terrorist organization. Part of that was a provision that said, but the FBI may not initiate an investigation of the crime of material support based solely on First Amendment protected activity. Then in the 1996 anti-terrorism law, they deleted that protection, which led me to assume that they were going to initiate investigations based solely on protected First Amendment activity. So it's the base solely. We haven't won that. If we won that, then we could talk about what else.
Aziz, hi.
Hi, I have a quick question for Geoff and a quick question for Nura. So the question to Geoff is so I was puzzled that you, on the one hand, talk about the constraints imposed by the Constitution as essentially being those constraints embodied in the court's doctrine, and say that what the FBI has done in the guidelines is gratuitous. It's gravy. We ought to be happy about it, right? It's surprising to hear the constitutional constraint on government actors framed in that way, because the court itself doesn't frame constitutional protections in that way. The court itself says, particularly in these public safety contexts, particularly when what the court can do, the only thing the court can offer is ex post regulation, which may be very costly, very limited. Often it's going to be clashes of one person's testimony against another that courts turn out not to be very good at resolving. That the constraints that the doctrine imposes are much more limited than they otherwise might be because of the institutional constraints of the court. And in fact, the Constitution in this context, to use a phrase I know you're familiar with, is under-enforced, right? So we might think that it's incomplete to talk about the First Amendment in this domain as being summarized or by what the court has told us about the First Amendment. And we might look at things like the Levi Guidelines and their ilk as attempts to take the First Amendment seriously by political actors. And surely we ought to be talking about those as mandatory, just as the provision of criminal defense services by the states that choose to have criminal penalties is mandatory in some meaningful way, right? So and it may be that part of the problem in this domain is that we don't take that kind of constitutional norm beyond what the court tells us, which may be limited for very good reason, seriously, right? So I mean, I wonder whether I'm reading you right or whether there's
No, I think that's a great point. And although I wouldn't want to frame it only in those terms, because I think there's also good public policy independent of what the Constitution demands. So yes, there is a middle ground where you could say the Constitution should be understood as demanding that the government follow certain procedures, even though the courts do not require them. And I think that's perfectly sensible. But I also think that the problem with that as an argument is that it's easy to say, well, says who? And therefore, thinking of it as good policy is reinforced by constitutional values, is I think the better way, more effective way to put it. But I don't disagree at all with the proposition that there should be understood to be constitutional obligations on government that are not necessarily judicially enforced. Standing is a great example. Courts can't enforce it. It doesn't mean the underlying action that the government is doing is constitutional. So yeah, I accept that. I just think you have to be careful not to treat that as the kind of limitation for what public policy demands.
Sure. Go ahead.
So I wanted to push Nura a little bit, and this actually piggybacks nicely on Jeff's answer, on a point that I think was implicit in Chuck's presentation, but I want to actually frame Chuck's point more sharply and hear how you respond to it.
Please.
So what you effectively told us is that the decision to focus on a particular ethnic or religious group, or the decision to inquire about religious faith, once a person has been singled out, has costs. It has costs that we call chilling effects and the like, right? And your implicit claim was that this is constitutionally problematic. The trouble with that is that there are no constitutional rights that are absolute, right? All constitutional rights in the equality context, in the First Amendment context, in the due process context to some extent, are balancing tests, right? And we need to look when we're conducting a balancing test, actually, at the kind of policy considerations that Professor Stone just talked about, right? We need to think about not just costs, but benefits. And in particular, we need to think about if the government has decided to use, say, X criteria, right? Is there some alternative? Is there something that is more narrowly tailored, to use the legal jargon, that is less costly, right? You need to be able to show that the government is not pursuing a policy goal, which everyone concedes is serious, in a way that is the most tailored that it can, right? So the problem here, I'm not sure you've made that case. What you've said is that there are costs to this policy, right? But given, so to be sure there are costs, but perhaps those costs are simply the costs that have to be borne given the scale of the problem, right? And what you have to tell us is what the more narrowly tailored alternative is.
And the other thing, just to sharpen your point, is I defer. Is what about the benefits, and how do you answer the question? Well, we got the Herald Square would-be bombers, we got the Newburgh 4 by putting informants in mosques.
Right, or if not religion, then what?
So this is an interesting conversation Liza and I had last night, which we didn't get into. But the surveillance of mosques, for example, I'm just going to use that as an example, is, I think, based on a premise that we're all sort of taking for granted. And it's something that FISA discusses in her report as well, about this concept of religiosity or mosque attendance tied to the propensity for violence. And I challenge that. I challenge that premise. And not just me, experts challenge that premise. We know there was a Duke study that came out last year that said mosque attendance actually is found to be, regular attendance at a mosque is found to decrease levels of extremism in those who are attending services. And Mark Sageman, in his testimony in front of the Senate Homeland Security Committee, specifically said those who commit acts of violence in the name of Islam are not Islamic scholars. So we're talking, so I want to sort of challenge that underlying presumption that I think that got lost in this discussion, is that the focus on individuals who attend religious services, or those who, I think it was mentioned earlier, sort of start growing a beard or start displaying visible signs of religiosity, that they're somehow tied to a propensity for violence. And so
That's a good answer. We're going to...
I could suggest at least two narrowly tailored.
Would they be fast?
Yes.
Okay.
Communications with Al-Awlaki in Yemen, whose communications are being monitored by the United States government, or what?
Go on. We don't have time. Go.
To start an investigation, or traveling to a terrorist training camp in Pakistan and asking the Pakistanis to give us the names of Americans who've ended up in those places in Pakistan.
All right, we have one last question.
Well, I had a question for Kate with regard to the guidelines. Is reform of the guidelines the goal we should be fighting for? Are you convinced that that is substantive enough? When I read the Inspector General report that you were referring to about domestic surveillance under the Ashcroft guidelines, it was extremely disheartening to see the guidelines used to rationalize several violations, and then there were absolutely no remedies or sanctions for violations of the guidelines that were identified in the report, including environmental activists ending up on the violent gang offender list, and Catholic workers, civil disobedience being characterized as terrorism investigations. That was my first question, Eliza. Two, very briefly, Geoffrey and Nura, you both referred to the chilling effect, and Chuck mentioned the problem with anecdotes. And is it enough are we meeting our standard of proof to show a chilling effect just by relying on anecdotes and subjective information? David Cole, in his book on Terrorism and Constitution, refers to the Philadelphia Meeting House case in the 60s, where information gathered about peaceful protesters was handed over by law enforcement to the press. And the court said that might be sufficient, as it was enough to get to the jury, because we could show actual harm, or at least something closer to concrete harm. Are you aware of any efforts, or do you foresee that if we further develop the empirical data, the social science and psychological and polling information to prove that these effects on our democracy and civil society are real, do you think we could be more successful at First Amendment litigation?
Who's on the court?
This is an imaginary court.
Yes.
Yes, before the imaginary court.
Yes, for the imaginary court. No, yes for, it's perfectly plausible legally to take that approach, just not with this particular makeup of the court.
It might, you might be able to, it might help you get in the door, but once you're in the door, there you are.
If we were called the Westboro Baptist. Oh.
Okay. Okay, that's, 50 words or less. Actually, no, go ahead. Take your time.
I think it's important to look at the surveillance authorities more broadly and comprehensively, and that I'm not sure just reforming the guidelines is enough. Although maybe on this particular problem, I think that we should have a higher standard for going into a religious place of worship, and that could be done by simply reforming the guidelines.
Nothing's going to solve the problem completely, but that will make a significant difference.
Nura, Chuck, did you have anything you wanted to add?
Not me.
Okay.
Thanks.
Well, thank you. We've run a little bit over. Thank you so much for your attention, and thank you to the panelists. You did a wonderful job.
Thanks for inviting me.